Today on Off the Clock, we're talking about the Fair Labor Standards Act, my favorite and yours. There's new regulations again, and we're going to talk about what they are and what organizations should be doing to prepare.
Welcome to Off the Clock, the webcast of employment attorneys at Miller Johnson, where we discuss what is happening in the HR world and provide practical insight and advice.
Hi, Sarah.
Hi. Yeah, is this 2016 or is this 2023? I forget.
Don't forget about 2019.
Yeah, right. Exactly.
Yes, it does feel a little deja vu-y,
Yeah.
if that's a word. But there are certainly some similarities to what we went through before with the Fair Labor Standards Act regulations, but we still need to be on top of it, right?
Got it.
Just because we're tired of talking about it and hearing about it doesn't mean it's still not important.
Okay.
Right?
All right.
And we also have newer folks, right, that weren't in HR in 2016.
16.
I hate to break it to you, but that was a while ago.
Yeah. It seems like yesterday, of course.
Yes,
So-
there are children in kindergarten that were not born yet when the regs were
I
last
see.
proposed to be
Wow.
changed when it comes
Yes.
to what we're about to be talking
Okay,
about.
then.
Okay, so let's talk about what the regs are and what we need to be doing to prepare. And everyone's question this time around is, are they actually going to happen?
All right.
Right?
So what is going on, as many of our listeners probably know, Rebecca is our FLSA wage and hour expert. So you have been on top of this.
Yep,
This is exciting to you.
it really is. And I know that's not very complimentary to myself, but I'll own it. I'll own that nerdiness. So the regs, like many versions before, deal with the minimum salary for someone to be properly classified as exempt from overtime requirements under the Fair Labor Standards Act. Now, that's a very long sentence, so let's break it down, right? So most people in business and HR are familiar with these terms, exempt or non-exempt, right? So what that really means is the Fair Labor Standards Act requires that every employed person be paid an overtime premium for all hours worked over 40, except those that fit within exemption. So they're exempt from that aspect of the Fair Labor Standards Act. So that's what it actually means to be exempt.
Exempt or salaried. I hear a lot of employers use the term salaried.
Oh, sure.
Right?
Yeah.
But
Salaried
what
or
they really
hourly.
mean is exempt or non-exempt. Or
Yes.
that's the legal term to
Thank you
use.
for that foreshadowing.
Yes.
Because we're going to talk about at the end how non-exempt employees can be paid.
Can be
on
paid
a
by the salary. I know,
Yes.
it's tricky. Yeah.
So to be exempt under the Fair Labor Standards Act, so you don't have to be paid for overtime, you have to the employee has to satisfy 3 tests. We're only really going to be talking about one today, but they have to satisfy 3 tests. One is they have to be paid the minimum salary as set by the most recent DOL regulations. They have to be paid on a proper salary basis. So even though your intent is to pay them that minimum salary, you have to actually execute on that.
Meaning you
correctly.
can't reduce it. If an employee maybe only works 20 hours in a week,
Right.
we can't make reductions to their salary for having worked less unless now see, it's the FLSA, so there's always an unless and there's always exceptions.
An
but there
exception
are
to
only
the
certain-
exemption.
Yes.
Right, but we're not going to talk
Thank
about those.
God we're not talking about those.
Can we? We'll save that for another episode.
We'll save that for
right?
another
The exceptions to the exemptions. But that, yes, you have to pay people that at least minimum salary correctly. And this is the part that really trips people up the most, they have to satisfy one of the
duties.
exempt duties tests. So we're not going to get deep into the duties tests and the ins and outs, particularly of the executive or the white collar exemptions and duties tests. But we're going to focus on that minimum salary because that's what the regulations aim to change. But I don't want listeners or viewers to walk away thinking that that's all that's necessary.
Those
for
other
someone to be
two,
exempt.
those other 2 requirements still exist.
They still exist, yes. And I will say, I do think if the minimum salary goes up, a lot of those borderline folks regarding duties, those will kind of fade away.
I agree.
Right? Because the ones we struggle with the most tend to be on the very lower end. right, of the exempt salaries.
Meaning employees who are making just that
Right.
the current minimum salary,
Right.
whether they're actually performing the duties that meet the exemption can be, let's say, gray.
Yes, at least for the administrative test, right? That's where we spend the most amount of time cogitating. So if we can think about an upside to this new rule, I always like to think of some sort of positive silver lining. At least we won't have to talk about duties tests for some of your employees because they won't meet the new minimum salary anyway.
You won't be paying them enough for them to meet it. Okay,
Easy breezy. So
what is it?
What is it? It is projected to be $55,068.
Now, why do you say projected to be? Why is it not
So
a
the
certain
new
amount?
proposed rule, and it is a proposed rule, we're going to talk about this a little bit in the timing aspect of it, includes automatic adjustments for inflation. So we'll
Okay.
have to look at by the time it becomes a final rule, assuming it does,
I see.
what happened with inflation. And then every year after that, right, if this becomes a final rule, you should expect to see that minimum amount change every year.
Oh, okay.
We probably won't do a podcast on it every year, but it'll be like for folks, at least in Michigan, where the minimum wage in Michigan has been changing every year for a while, that's what this is going to be like too. So we've got to get comfortable with that.
So
concept.
if a business has an employee that's just paid that very minimum salary under the FLSA,
Right.
that employee receiving the minimum salary is going to get an automatic increase each year, and that employer should keep on top of that and make sure they know what that's going to have to be.
Correct.
Got it.
Correct.
Okay.
And by the way, I never recommend someone pay the exact
No.
minimum. It's just too risky, isn't
I
it?
agree.
I'm just too risk averse for that.
Always leave some
If
cushion.
you're going to pay someone $55,068, why not just pay them $55,070?
just in case.
How about
Or 60.
55,100? Right?
Yeah.
Like, why cut it
Yeah.
that close? It's just it makes it just I don't like it. So always just round up, at least on that. It also, the new regs increase the amount for the highly compensated employee. I consider that kind of a shortcut. There is still a duties test. We're not going to get into that. A lot of people skip that with highly compensated employees. There is still a duties test, but it gives you a shortcut, and that salary will be increased, minimum salary, from $107,000 to $144,000. I am rounding, following my own advice.
Okay.
So that's a pretty big jump.
That's a big jump
There.
And I don't think we talked about for the non-highly compensated employees. I know you said it's projected to be 55.68, and it is currently what, around 35?
35 and some
Okay.
change, so it rounded to 36. Yeah.
So that's
a
that's a significant jump. I mean, that's from a percentage standpoint.
yes.
Right, it's dangerous for me to do math, but that's a significant jump. That's
And you
more than
aren't.
a
You're saying
20%
significant.
increase. I'm grasping here. I'm moving the decimal point. Yeah, but that's more than that's a significant
Yes, for
increase.
someone making 35,000 to jump to 20,000,
jump 20,000 more.
is significant. So my guess is this is going to result in more of the workforce, right, being classified as non-exempt, because not everyone, right, is going to get, right, certainly those close to the borderline might, but folks making 35 are probably not going to jump to 55, right, because then you have wage compression and it has ripple effects all the way to the top. So how many people will this actually impact? The DOL, Sarah, has done the calculations.
Okay.
And they are very excited. As excited as DOL bureaucrats can be.
I see.
I think I'm more excited about the Fair Labor Standards Act than the DOL. But anyway, for putting aside the highly compensated employees, they expect the impact will be for 3.5 million
Workers
currently
are in that
exempt
delta.
employees are in that delta. So if no raises are given, 3.4 million more employees, as the DOL says, will happily start earning overtime than they didn't before. And this is a wonderful way to get more money in people's pockets.
Interesting. I find that such an interesting spin because you and I talked to a lot of clients back in 2016, which is the last time the DOL made a significant
Right.
proposal. It proposed to make a significant increase like this. And what we heard was really kind of a mixed bag from exempt employees. Some exempt employees, yes, were thrilled at the idea of having either a salary increase or the opportunity to be paid overtime. Some exempt employees really have an emotional tie to the idea that they are exempt in salaried and feel that it gives their job additional credibility, right, and importance.
I completely agree.
I'm not sure the Department of Labor appreciates that emotional reaction. The other thing I would add too is for an employer that really can't afford to pay an employee more money, isn't there a way to adjust their income so that they're paid overtime but continue to make the same $36,000 that they're making now, Rebecca, right? I mean, because
course.
then
And
the minimum, we just have to pay the minimum wage,
as long as
right?
it's minimum wage, there's no guarantee that people will be making more money. They may make overtime their total annual income. We'll talk about that a little bit later, but you can do anything you want as long as it's at least minimum wage. So this does not necessarily mean, contrary to the DOL's prediction, that 3.4 million more employees will start making more money.
Well, yes.
That's what the DOL is trying to do. But of course, it doesn't automatically result in that. And can I just vent for a second?
Oh yeah.
Okay.
I'm always a safe venting
Okay.
space. You know that.
Okay, we'll just pretend no one else is listening. Okay, here's my vent. When the Fair Labor Standards Act was passed and implemented for the first time, it required overtime rate. The point was not to get more money in people's pockets. The point was to create an incentive for employers to employ more people. Because the idea is, if I have 80 hours of work that needs to be done, and I hire just Sarah to do the 80 hours, I got to pay overtime on 40 hours, which will cost me more money in the long run than employing 2 employees.
Interesting.
So that really was the purpose of that overtime requirement. Okay, it wasn't about fairness. It wasn't about. It was about employing more people, right? This was they wanted to. It was just past the Depression, et cetera, et cetera. What's happening in the labor market now, Sarah?
Yeah.
Right. Okay.
Right. We don't even need to say it out loud again. I don't.
Right.
Think,
So now we're going to be incentivized to hire people at, again, historic all-time unemployment lows.
Right.
It really, to me, doesn't make sense when we think about the purpose of the Fair Labor Standards Act. But that's my vent.
That's a valid point.
I digress.
The timing is suspect, right?
The regs are the regs.
Yes.
Right. Well, it's obviously they've digressed from the original purpose. And now they're trying through another agency's non-compete act and other things. They've been making a number of efforts to get more money right into employees' pockets and out of businesses' pockets. I mean, that is an express goal of the current administration, to shift the wealth a little bit. So when will they become effective, these new draft regulations?
Speaking of timing,
right.
What is the timing?
As if we couldn't get more boring. We're talking about the Fair Labor Standards Act. Now let's talk about administrative procedure. Stay with us. This will just take a second. All right, so in September, the Department of Labor issued draft regulations, as I mentioned.
Yes.
It's called a notice and comment period where everyone, including you and I.
Oh, they'll probably be watching this podcast, I would imagine,
we'll just
right?
send it to them. I'm sure President Biden is.
Yes. For
Hello.
for your comments.
For my comments on the purpose and why are we doing this. So there's a 60-day notice and comment period where everyone can give comments. Then there's an unspecified period of time during which the DOL considers those comments, and I'm sure they do very, very carefully. Because again, this is the third time there's been a notice and comment on increasing the minimum salary. They've heard it all, but anyway, there's some period of time they are required to do. I won't get into the details, but they do have to do something with all of those comments, and then they issue a final rule. And this rule, when I say rule, regulation, same thing, becomes effective 60 days from the date of publication of the final.
Okay.
Important point number 1, employers will have 60 days notice.
For sure.
To comply.
At a minimum.
Yeah. And important point number 2, my prediction is the final rule will probably be issued at the earliest, like late winter, early spring.
Okay.
Possibly even later than that.
Right.
Sometimes they take even longer. But
Depending on where you live, that could be a different time. Here in
Yes.
Michigan, that could be June.
which is spring. Yes. Or late winter.
Or late winter.
So now let's get to everyone's big question. This is the question whenever this comes up, that
right.
every client or
Is
or
it
person
going
that
to
counts,
happen?
Is it even going to happen?
Right.
So for those of us that were around in an HR in 2016, you will remember that there was this huge jump under the Obama administration, right? This reg that proposed a huge jump. It was a final rule with a enforcement date coming soon after Thanksgiving.
People had it lined up. They knew exactly what they were doing.
Some people
They
already
had
got
told
their raises.
employees.
Some people's classifications had already changed, right? And then a court in Texas, one judge,
Federal judge in Texas.
it's always Texas,
Always Texas.
decided that the regulation was unlawful and enjoined it nationwide, right? Meaning that it did not take effect pending further legal proceedings, appeal, blah, blah, blah.
Isn't that amazing? One federal judge.
And I remember when it happened,
Yeah.
yes, one federal judge has all that power, which is another issue that's being debated actually about whether individual judges and individual cases can issue national injunctions. That came out of the whole COVID era, that concept, but I digress again.
Yes. Tell us about Thanksgiving 2016.
So, Sarah, once upon a time, it was Thanksgiving Eve in the Strauss household. In 2016, I always host Thanksgiving.
Yep.
I had sides like in the oven, and it was around dinner time when this court case
And your world fell apart.
broke. Right, and the sides burned and the pies
The
were
Strauss
ruined.
family will never forget.
Yeah, right. We ate Spam for Thanksgiving that year because I was busy all that night and the next day and my entire Thanksgiving break on the phone, sending emails, right? All of these clients and organizations we had worked with to get them ready for the new rule, telling them,
Telling them,
you don't have to do that anymore, right? Okay, so the disruption to my life is inconsequential compared to the disruption in our clients, right? That especially those that had a lot of people, right, that were in that delta that were going to be reclassified. So now there's a little post-traumatic stress disorder. PTSD, thank you. About that. So now the number one question is, I think I'm just going to wait, right? I think I'm just going to wait and see what a court does with it. So is that a legitimate strategy? Number one, I'm not sure what's going to happen with the court challenge this time. First of all, the court challenge can't come in until the final rule. I 100% guarantee you there will be one, but I can't tell you right now there is one as we're sitting here talking today. But again, in Texas, there was a challenge to the Trump administration's change in the minimum salary, which was much smaller, only about 10,000, 12,000. But there was still a challenge. And in Texas,
it must have survived because we didn't.
It survived.
Yeah.
And now it's on appeal. And so the Fifth Circuit is the Court of Appeals that governs Texas as well as some other states. If the Fifth Circuit affirms, meaning they agree, right, that the Department of Labor had the administrative authority to raise, right, the salary for these white-collar exemptions, then that will certainly color my prediction of how a challenge to this regulation would go.
The challenge to the Trump raising the salary is still in front of the Fifth Circuit?
Yes, it's being appealed right now.
How many years has it? I mean, that's been several years, yes? They're still challenging the last one, and we got another one.
The wheels of justice are
sorry,
slow.
Listeners.
The wheels of justice are slow.
We still don't know whether the last one is going to.
But anyway, I wouldn't go into this one assuming that this reg is going to be overturned. If it wasn't for this recent Texas decision, I would assume this one would also be overturned or at least stayed and then not appealed. But now, I don't know. Okay.
Yeah.
So I don't know how to predict how the legal challenge will turn out.
And let me just add this just little thought and reminder about 2016. The second part of what happened in 2016 is then we also had a change in the administration.
Yeah.
Right? And so the DOL, once that Texas judge enjoined it, right, found it unlawful back,
Which we know
in
was
November.
the end of November, right? I'll never forget.
Of 2016, Then we had a change in administration the following January, and the DOL just dropped it at that point.
Yep.
So we don't know what the end game would have been.
Correct.
Had that change in administration not occurred and had it been appealed up to the Fifth Circuit and then the Supreme Court of the United States. It simply got dropped because there was a change in the administration. Well, we have another election in 2024, which could also play into all of this. And so whether there's a change in administration could also impact the long game here.
This really is feeling deja vu-y,
really
isn't
is.
it? In more ways than one now. Okay, so back to the key question. I promise I'll answer. Is it an okay strategy just to wait and see, right, what happens? Kind of, sort of. It's okay not to actually pull the trigger and implement the changes until the final rule is issued and effective. Okay, I am comfortable with that if clients are, but I do not think it's okay to not think about it or plan for it until that time.
Not even understand how it would impact the organization.
I highly recommend that you plan as if it's going to happen, and then you may choose not to implement your decisions.
So what I hear you saying is listeners have a plan, which would start with finding out who this impacts, right? And then understanding the options for those employees. But it's okay to wait to act on that plan until we know for sure.
Absolutely.
But have the plan in place.
This is very similar to our advice with the OSHA vaccines. Do you remember that?
Yes,
The
I do.
case is pending in the Supreme Court. We said, have a plan, but go ahead and wait and hear what the Supreme Court says.
Yeah.
Right, so similar kind of strategy.
Okay.
But I think it is too risky to wait until a court makes a decision to decide to whether even think about this.
Yeah.
Depending on your organization.
And the
right?
size,
If you don't have a
right.
lot of people, exempt people, right, in that salary range, then maybe, right? Not this is not going to take you long to figure out. But for those of you that have a lot of employees, right, in that 20,000 delta, you're not going to want to wait.
Okay.
And just do that over 60 days.
So what are the options then for those employees that fall into the delta between the 35 now and the 55 or so that is likely to come down?
So let's talk about the obvious. People don't need us to tell them, frankly.
Right.
One is, as we already mentioned, give them a raise. Right?
Okay.
My guess is that will happen to people that are maybe within 5,000 or so, right, of the new minimum. But just keep in mind, if you do that it's going to be changing frequently. I think it's set to be adjusted every 3 years. So you'd have that 3 year. But you're going to essentially be guaranteeing the employees a cost of living type of increase.
Okay.
And you're going to have to stay current on the law on that, et cetera, et cetera. But that is certainly one option.
Sure.
Another option is to switch them, right, to being non-exempt. If you do that, and this will happen for a lot of employees, particularly those closer to the 35, 36 mark, right? What are your options there? We talked about this a lot in 2016, but let's talk about it again. Because there's a number of different timekeeping mechanisms and a number of different ways to pay, what people refer to as hourly employees.
Yes.
So when it comes to timekeeping and the psychology of it, this goes to your point earlier.
This is why you love the FLSA.
Dude, there's so much practical.
Not many people talk about the psychology of time.
That's why I'm such a treasure. So a lot of employers are concerned that when they switch someone from being exempt to non-exempt, there's going to be demoralizing impact of having to punch in and out.
Yes.
Right? So the law doesn't actually require employees to punch in and out. Punching in and out is great evidence, right? If we're sued later, or if the
make
DOL
sure they were
audits
paid
us
for it.
later and they want to know when the person was actually there, well, we have the punch reports. But that doesn't actually say when someone's working. It's just evidence of when they punched in and out. But it's not bad evidence, right? But there's absolutely nothing wrong under the law with having people write in on a timesheet when they come and go.
Yeah.
Right? And how about this? This goes to timekeeping and how to pay people differently. So hourly, so non-exempt employees can actually be paid a salary.
Yes.
We can actually tell them you're getting paid X amount per week.
Salaried, non-exempt.
The
I've heard
trick
of it.
is The trick is we still have to know how many hours they're working a week because they still are entitled to their overtime premium for all hours over 40, right? So we have to make sure we're doing that, and we have to make sure we communicate very clearly what's going on so there's no confusion.
It would seem to me that that would be a better option for employees who don't typically work a lot of overtime. Am I right? Because it seems like the administrative work that would ensue from having to pay that additional overtime to that employee is significant.
Are you sitting down?
I am. I'm right here, seated. Yes.
Listen to this. Okay. So we can combine, it is exciting. We can combine a salary for a non-exempt employee with another way of keeping track of time, which is called the exception method.
Oh.
This is actually in a Fair Labor Standards Act regulation and is perfectly acceptable under the Fair Labor Standards Act, which means we will assume you are working, pick a number, 40, 50, 60, whatever you want, per week. And we will pay you for 40, 50, 60, 20, whatever you want, every week. If there is a week in which you work more than, here's how to let us know.
You have to
and
tell
you will
us.
be paid for those additional hours.
Got it.
Okay? Now, we can try to make that number really close to what we think the person is actually working, or we can make it high. So that way, little variations in how many hours someone is working a week doesn't matter. If we're already paying them for 50, no matter how many hours they actually work,
Then that's
if they work
fine.
40 1 week and 42, it doesn't really
Fascinating.
matter.
So for the non-exempt, now to be clear, we are talking about non-exempt salaried employees.
Yep.
We can have that salary assume they're working more than 40 hours a week, so included in the salary is the overtime.
Yes.
Am I tracking this?
You are absolutely tracking that. So they still get
love
time and a
this
half for
idea.
for a 50-hour week employee. They get time and a half for the last 10 hours, but it's built
already
into
baked
the
in.
salary. This has to be communicated very, very clearly.
Yes.
We recommend legal
I'm sure
review
they're supposed to sign off on it.
They are absolutely supposed to sign. I mean, that's not required, but we highly recommend it as
Yeah.
best practice, and we recommend that a lawyer review the language to make sure it's crystal clear that they are getting paid time and a half for those last
Interesting.
hours. Okay, now, are you sitting down?
Still sitting.
Still sitting.
Still sitting.
Listen to what we did here, Millers. This is not going to be impressive to a lot of people, but it's impressive to me. We sat down and put pen to paper and literally wrote a formula,
A mathematical formula? Does our general counsel know about this?
a mathematical formula. So, if you have a salaried exempt employee today, and let's just say she makes $40,000 a year,
Okay.
the new regs become effective. This person is going to be non-exempt.
Right, that's the
You're not
decision.
gonna
We're
give
going to
her
make
the
her
raise.
non-exempt. Okay.
Okay, so she's going to become non-exempt. You can still only afford to pay her
40.
$40,000 a year. If she never, ever, ever works a minute over 40, just divide 40 hours into 40,000 and you've got the hourly wage rate, right? But what if she normally works 45 hours?
Yes.
Or 50
That's
hours?
beyond my
Or what if it
mathematical
varies a little bit between 40 and 50
Right.
in a given week? You can say, we will pay you a salary that represents, right, up to 50 hours. The last time will be the overtime rate. And our formula figures out what the hourly rate then should be that should then feed into the salary, the weekly salary,
Wow.
to make that work. That accounts for the overtime premium
Got
part
it.
of the non-exempt
Got it.
salary.
So first you have to figure out the hourly rate based on the 50 hours a week that employee works, and then you can turn it into the new non-exempt
We actually work
salary.
it backwards. The beauty of the formula is we start with how much you want the person to make in a
Yes.
year.
Yeah, and work
And
it
then we
backwards.
back into what the hourly rate should be.
Right.
And by the way, you can do that even if you're not doing a non-exempt salary. Let's say you want to pay the person hourly.
Yeah, sure, that
But
works
you know
too.
they're going to work usually 10 hours of overtime a week or whatever the number is. We can get you what the hourly rate
Yeah.
should be. And probably a lot of people are laughing at me right now because they're like, Rebecca, we're not lawyers. We know how to do math. And
Yeah,
so this
no,
is,
it's not that. It's very
right,
exciting to
but
me.
it's very
yes.
exciting to me that we did that.
Excellent.
So it's not the end of the world,
Right.
and it's not something that's happening tomorrow. Although this is right, people are listening to this probably just before Thanksgiving.
Right.
This is not going to be a Thanksgiving surprise again, like it was in 2016. But it's time to start thinking about it. And as folks are thinking about their to-do list for the new year and priorities, one of the things I want every organization to do is to plan for the new rule as if it might be
I
implemented.
think that makes sense. And I would add too, I think that there's been a fair amount of news coverage. This is out there. So our listeners may be getting questions from employees as well, right? So
Yep.
I would add on the to-do list, think about how you're going to answer those questions about, for example, how is this going to impact me if I'm currently exempt and I'm making $47,000 a year?
Right, exactly.
Excellent.
Okay.
Well, thank you for all of the good information.
You're welcome. It was fun.
Thanks, Rebecca.
Thank you.